do you mind hitting record for me?
Yep, we are recording now.
All right, perfect. Thank you so much. Just a couple housekeeping items and kind of introduction for people who are new to the group. This is the Austin Women's Investing Group. So we are a dynamic and diverse group of women who enjoy learning and sharing investing ideas in a comfortable all-female setting. I am Sarah Glakis, so I'm typically the person who is sending you the messages about the meetings. I'm an investor myself, an advisor, and the founder of Black Barn Financial and the Austin Women's Investing Group. So my friend Michelle and I, back in 2011, we started Austin Women's Investing Group as a way to get a bunch of women together in a room to talk about money. And so that's still what the group is today. It's 10 years later. We had our 10-year anniversary in March, and now we have over 2,600 members in our meetup group and over 1,000 women in our private Facebook group. So, you know, I think, again, like one of the benefits about, you know, that's come out of kind of the pandemic era that we went through is we're no longer just the Austin Women's Investing Group, which is really cool. I'm assuming that some of you who are on the call aren't necessarily in Austin. Maybe not necessarily in Texas, and sometimes we have folks who aren't even, you know, living in the United States. And so we welcome everyone who's able to be here from wherever you're coming from. So thank you for joining us. I will say today's topic is specific to Texas because Catherine's going to be talking about family law in the state of Texas. But if you're not from Texas, please feel free to stay and just kind of stick with us and learn with us, and certainly come to our other meetings as well. The group benefits from investors with various levels of experience. A lot of times I hear from people when I invite them to the group, people will say, well, I don't know anything about investing. So I just want to let everybody know that that's the whole point of the group. This is for people who don't know anything about investing, and it's for people who know a lot about investing. This is the place where you can come to ask any question. So all the questions are, you know, put them in the chat box. This is where you can ask any of the questions that you have on your mind. And at the same time, if you see a question in the chat box where you have some experience or some insight with the topic, please share your answer. You know, feel free to respond and give feedback to that person who's asking questions. That's how our in-person meetings went, and we're trying to kind of keep the spirit of those in-person meetings when we're on Zoom. So we're trying to make it as interactive as we can, while still, you know, kind of keeping it on the topic that we've chosen for the month. As I mentioned before, Gwen, Lori, and I are going to be kind of collecting the questions that you drop into the chat box, and then one of the three of us will stop Catherine as we go to either ask her the question, or we might advisor to get advice that's specific to your needs. All right, whew. I think that's all that I have to say at the very beginning. So without further ado, let's turn it over to Catherine.
It's great to be here with all of you. I'm really happy to be doing this talk. And the reason I'm really happy to be doing this talk is that I'm usually having this talk with someone who's come to my office, or I'm meeting with them on Zoom, and they're at one of the lowest points in their life as they're facing a divorce. And that honestly is when most people are learning about this information for the first time. And I think, especially for women, but you know, all people, I think it can be empowering to have this information before you're in a relationship, or even while you're married, before you're in a situation facing divorce, because you can make different decisions. I've seen many, many people, you know, come to my office and they're learning this information, you know, while they're facing a divorce, and it can be very shocking and surprising what they learn. As Sarah said, I'm not here to give any individual personal advice, but I'm always happy to talk to people. So if you want my contact information, if you have your own, personal situation that comes up, or a friend or a sister or something like that, I'm always happy for people to call my office. And if it's not me, I can point you in the right direction. Let's see. So one thing I want to start with that's very basic actually is what marriage is and what it isn't. This is particular to Texas, but most states have a law about common law marriage. So it's not just living together, but for example, in Texas, you are as married as any other kind of married if you are common law married. And to be common law married, you have to have lived together, and it's for any amount of time. I mean, it could be a week. Some people think it's 7 years or 10 years. That isn't the case. You also have to intend between the two of you to be married. So the two people have to, between them, say, we intend to be married to one another, live together. And then the third component is really important. You have to hold yourself out publicly as married. So that could be as simple as you start introducing yourselves to your friends and family as husband and wife, or wife and wife, or husband and husband. That's not the best evidence. Better evidence sometimes is buying property together as spouses, or filing tax returns together as spouses. So those three components would have you be common law married. And it is, again, absolutely as married as if you went and got a marriage certificate and had a ceremonial marriage. So I'm just saying that so people out there, if you are living together with someone and have any concern about, does us, living together make us married? It doesn't. Or, you may be in the opposite situation where you could be inadvertently creating a marriage that you aren't intending to create. So that is what marriage is and isn't, and I'm happy to answer any questions about that. So just the basics about property law in Texas. Texas is a community property state. I know a lot of people have heard that. And when I'm talking to people, a lot of times they think what that means is that in a divorce, well, in a marriage, that everything's owned 50-50, and then in a divorce, everything is divided 50-50, and that's not what it means. So what community property means is that there are 3 estates. So it is a legal presumption, and that's important because when the law presumes something, if you want to prove something different, you have the burden of proof to demonstrate that something is not community property. So the presumption is that once you get married, the day that you cross that line, everything that you accumulate, whether it's an asset or a liability, belongs to the community. So the community is the collective of the 2 people, and that includes your wages. So it's, the day that you get married, the next day, whatever you earn, your earnings belong to the community. So does your spouse's earnings. And then anything that you acquire, a house, contributions to your retirement account, debts, and I'll return to debts. I'm going to address that with you guys. Because sometimes people don't realize that if your spouse is racking up a lot of debt, it's community debt, even if you had nothing to do with it. So the presumption is anything that happens during the marriage financially belongs to the community. So that's the one estate is the community estate. The 2 other estates are your separate estate and your spouse's separate estate. And the separate estates are anything that you had before marriage, whether it's, a ring that your grandmother gave you, or, money in an IRA that you inherited from somebody. Anything that you had before marriage, and then anything that you acquire at any time, meaning before marriage or during marriage, as a gift or inheritance. So you and your spouse will each have a separate estate. The other thing that can be separate is a personal injury recovery. I don't see this very often, but if someone was in a car accident and they have a settlement, the part of the settlement that is for something other than lost wages is their separate property. So in a divorce, the community estate is not necessarily divided equally. It can be divided in Travis County, for example. We don't usually see what's called a disproportionate division that is outside the range of a 60-40 division. And I'm going to come back to that as well. But just knowing those basics as you're in or going into a marriage, I think can be very helpful. Because if you, and you know, I'm talking to women who are interested in investing, you may, you know, be someone that is already contributing to a retirement account and be going into a marriage with things that are already your own. You may own a condominium or a house, and I'm definitely seeing a lot more of that, you know, thankfully, where women may be getting married a little bit older and they're coming in with their own assets, their own investments. And so just to be aware of a couple things. So when you get married, number one, it does not mean that everything you both already have, that does not become owned by both of you. It's still your separate property. And also be aware that whatever the other person is coming into the marriage with is their separate property. Usually when I do this talk, one of the best and easiest forms of self-help that you can do, obviously when you're getting married, you don't know if you're ever going to face a divorce, but one really easy thing that you can do is just keep records of everything that you have going into the marriage. And I say that for a couple reasons. If you are getting married and you already have, let's say, $20,000 in your 401k, if you just save that statement from right before the marriage, if you are in a divorce 20 years later, you can pull out that statement and say, this was my separate money before we got married. That's important for a couple reasons. Financial institutions aren't saving those statements for so long anymore, and it can be really hard to prove your separate property, you know, 20 years down the road. So one very simple piece of advice is just keep a folder or, you know, an electronic file that reflects everything that you had going into the marriage. And if you're already married and, you know, the marriage is 7 years long or something, you can probably go back and get those documents now. Even if you think you'll never get divorced, it just will preserve your separate property.
Hey, Catherine.
Yes.
There was a question that came up in the chat about starting a business. So Brandy, feel free to unmute yourself if I'm not asking your question accurately, but it looks like, what about starting a business before you get married? Is that now community once you are married?
Okay, and also let me just say, I would like this to be conversational, so yes, please ask questions as we go along, because I want to address the issues that everyone here wants me to address. So in Texas, in terms of determining if property is separate property belonging to one spouse, or if it's community property that belongs to both people, Texas looks at what's called the inception of title. So it looks at when did that asset come into existence. So when it comes to forming a business, and this is good to know both ways, both when you're thinking about what is your separate property and when you're thinking about what is your spouse's separate property. So if a business came into existence before marriage, that would be that person's separate property. However, income from separate property is community property. So So income from separate property is community, but increase in value is still separate. And I'm going to use a simple example. I'm going to use a house, and then Brandy, I'm going to come back and talk about a business, okay? So let's say somebody owned a house before marriage and it's worth $100,000. They get married. At the point of divorce, people are trying to sort out which estate owns the house. Inception of title, it's the wife's house, it's her separate property. It's now worth $500,000. So the character of the house, the asset, is separate. So it belongs to the wife. It can't be divided in a divorce. And the increase in value is $400,000. Increase in value, so something becoming more valuable, remains separate. So it's wife's house. It's her separate property. Someone just made a comment. This is why women should never marry down. But and she keeps the house even though it's increased in value by $400,000. So a business is a little bit different. I mean, yes, the house can make income if you are renting it out, but with a business, let's say it was inception of title, it was formed before marriage. So at the point of divorce, it's separate property, whoever formed that business. But let's say over the years it was throwing off income and the couple used that income to live on, and they invested it, and they bought a home, they bought a vacation home. Anything that was acquired with the income of that business would be community. Is that, am I answering your question or questions that anybody else has about that?
Yeah, you answered it good for me. Thank you.
Okay, it can be. I've seen a lot of people be really, you know, that's the other. This may be one of the only chances I have to educate people about these things before they're in a divorce situation, and people just don't have this knowledge before they're in a divorce. And I've seen many people where there is a very successful business, and the spouse who's not the business owner is very surprised at the point of divorce that this business isn't ours. You know, often the spouse of a successful business owner has put in a lot of blood, sweat, and tears as well. Maybe they've done the accounting for the business, or they've set aside their own plans and dreams to have this business be successful. And they're really shocked to find out that they're not an owner of the business. And so whatever, you know, they're entitled to divide whatever was acquired with the income from that business. But let's say at the, you know, when the business was formed, it was nothing, right? People start businesses, they have nothing, you invest in it. Now at the point of the divorce, the business itself may be worth, let's say, $7 million. So that increase in value does not belong to the community. And that's often really upsetting to the spouse who feels like, and they did, that they participated as much in the success of this business. So Austin, for example, is a city with many, many small businesses, you know, mom and pop entrepreneurial ventures, and people are really surprised to find out that, you know, they're not going to get a piece of that at the point of divorce. Debts. So this is also something I would like you all to be very aware of, and this happens frequently as well. You may have one spouse that puts a lot of things on credit cards and they rack up a lot of credit card debt, and the other spouse is very frugal, doesn't do that, and now you're at the point of divorce and one of the spouses has $50,000 in credit card debt. And I hear people say, well, I didn't use those cards. I didn't know that person was spending that money. I don't want to pay for half of that. And unfortunately, that $50,000 in credit card debt does belong to the community, and it is split. It does not mean that so that a creditor cannot go after you if your name is not on the credit card. But if that spouse takes that $50,000 in debt, the other spouse is probably going to get $25,000 less of something. So it is divided. A lot of times spouses don't have a really great way to control what the other spouse does as far as credit cards. But, and I'll get to this in a bit, but there are agreements that people who are about to get married can make, or the people that are married can make, to alter the way that some of these things might work out. I also, back on that percentage division, the community estate, it is often divided equally, especially if you have two spouses that, you know, they earn comparable amounts of money and they're coming to the divorce saying, we both contributed to this, we just grew apart, we're going our separate ways. Often the community estate is divided equally. Where you might have what's called a disproportionate division is when, for example, one spouse has been at home while the other was out earning. The marriage has been a long-term marriage. Things like that, where the equities or the fairness would lead one to divide the community estate in some way other than 50-50. So for example, 60% to one spouse and 40% to another spouse. This also can happen in particularly Texas because of our alimony statute, which is another financial piece that I want you all to be aware of. When a spouse is at the point of divorce, and to be honest with you, it is still, I am seeing more high wage earning women, which is great. But it is still, I would say, 95% of the time, it is still a female partner that is the person in need of alimony. And, you know, it's not that fun to deliver the news about our Texas alimony statute. So alimony in Texas is very narrow. It's intended to be what's called rehabilitative, meaning to get someone back in the workforce or to get someone retrained or re-educated to get in the workforce. And it's intended to be for the least amount of time and the least amount of money for them to get on their feet. And the definition of getting on your feet in Texas is to look at if they can meet their minimum reasonable needs. So it's not the lifestyle they've become accustomed to. It's very, very minimal. And it takes into account what they get from the property division. So a lot of times when it's not looking good that they're going to qualify for alimony because our alimony statute is so narrow, we do start to look at a disproportionate division of the community estate instead of looking at alimony. Do you have any questions about that? Not right now.
Catherine, we
Yes.
did have another question about the business.
Okay.
Let's see, Veronica had a question. Unless formation documents are amended to reflect the spouse as owner too, would that mean that they both would own the business?
I want to make sure I'm understanding the question. Are you saying if the formation documents are amended to convey an ownership interest, or if they're not?
Veronica, do you mind speaking to that?
Yeah, no, my question was in regards to the business that was formed prior to the marriage. So if you amend the formation documents and add the spouse as owner to them, everything changes, I guess? They're both owners?
Yes. I mean, that, and that also, I see that happen more with regard to a house. So, but yes, if one spouse owns a business before marriage, and then after marriage, they take the formation documents and they do something official to make sure that both spouses are part owners of the business, then yes, it would technically it would mean that each, let's say the business is owned 100% by one spouse, meaning they don't have business partners, other business partners. They get married and then they do some sort of conveyance in the formation document saying, now this business is owned 50% by spouse A and 50% by spouse B, or any combination, 80% and 20%. Yes, that would mean technically it doesn't make it community property, but it would make it each spouse's separate property to whatever percentage the spouses agreed. I see this more commonly with a house, and I would strongly suggest for anyone out there in this situation, if you can swing it, I see very often it's a common scenario to, one spouse owns a house prior to marriage, or sometimes people are getting ready to get married and they know they're getting married in a year. So as part of that, one spouse buys a house, the couple moves in together, and of course they consider the house to be, their house, the first home that they bought together. But because of inception of title, it really still belongs to the one house, the one person who purchased the house. And so if you can swing it, if you are the spouse in that position of living in another spouse's separate property house, you can, by deed conveyance, acquire a 1/2 interest in the house. That's the most common situation that I see people feel very disappointed in, is they've lived their life and raised their children in a home. They've been married 20 years and they learn that they have no interest in the house, that the house belongs to the other spouse. The community does have a claim for what's called reimbursement, which is so the community, again, is the two people. And the claim for reimbursement is for the reduction of the principal balance of the mortgage. But usually that amount is so much less than the increase in equity in the house over 20 years. So that probably sounds kind of abstract, but again, the example I gave earlier, let's say spouse bought a house for $100,000. At the point of divorce, it's worth $500,000, so the equity's $400,000. The other spouse has no claim to that increase in value. But let's say that the mortgage, and this isn't very realistic because usually you don't have a mortgage that's exactly the value of the house, but let's say when they got married, well, I'll use a better example. Let's say when they got married, the mortgage on that house was $90,000. And during the course of the marriage, the community, with the partner's income, pays off that mortgage. So they pay off $90,000. The community, which is the collective of the two people, has a claim for the $90,000 they paid off. One spouse is, half of that is $45,000. So that claim that the community has is obviously far less than half of the increase in value, or it's far less than half of the equity in the house, which is now $500,000. And that's very disappointing to people. And it's often, a home that people have decorated and they've done the landscaping and they've raised their children there. And it's very hard to understand why you wouldn't have any interest in the house at the point of divorce. So Veronica, did I answer your question?
Yeah, you did.
Okay.
And now, talking about the specific example with the home, Does it matter when the conveyance is done?
It doesn't matter. Yeah, once, and you're leading kind of into the next topic, which is, you know, and so I saw that people had questions about premarital agreements. And usually when I give this talk, that premarital agreements does become a pretty big conversation. So there are things that people can do to alter the outcomes that are governed by Texas statute. And so they are the kinds of things we've been talking about, like deed conveyances, so conveying a 1/2 interest in a house or a business. It doesn't have to be 1/2, it could be any percentage, really. I had, for example, a case where the parties were going to use land, that real estate that was inherited by one spouse, to do a short-term rental business, and the other spouse was putting a lot of effort into that business, and that spouse was smart enough to say, hey, if I'm going to put all this effort into this, I want to be an equal partner. And so a 1/2 interest was conveyed to that partner. And it is, you know, fully that person's interest as much as the other person who inherited it. But so those are some of the things you can do to alter it. With real estate, it's very simple with deeds, but premarital agreements. So one thing that you can do short of a premarital agreement is what I mentioned earlier, which is keeping a file that just has a list and a statement from every account that you have before you get married. Often people think they need a premarital agreement, and they really don't if you do what I just mentioned, because you really don't need a premarital agreement that says this is all the separate property I own right now, if you are able to prove the separate property that you own going into the marriage with just statements. So that's a very, very simple self-help measure that you can do, or anyone can do. You know, tell your sisters, tell your friends who have assets going into a marriage, just to memorialize it, keep a record right before they get married. So if they're getting married in November, just save every October statement, and if they already own a house or a condominium, for example, save the deeds. And then to just do good record keeping as you go along in the relationship. For example, if someone owns a house or a condominium before marriage, and 5 years into the marriage, they decide to sell that house, take the equity from that house and buy another marital residence, to then memorialize, all right, I sold my separate house, I netted $80,000, I took the $80,000 and I sent it to the title company as part of the down payment on our new home. So you can trace that if you do get into a divorce situation, that you still have a claim for your separate $80,000 that relates to the separate property house that you sold. So just really good record keeping can help you a lot along the way. And then if you never, if there's never a divorce, there's no harm in having kept those records. Record keeping can also help you avoid, or at least know what you're doing, relative to commingling your separate funds with the community. So in that example that I just gave with the house, so right before marriage, that person has the deed record or the HUD statement showing I bought this house before marriage. So it's really easy to prove. Then if, let's say they sell the house and they decide that they're going to use money, separate money, to help buy another house that will be a community property house. If that person can track it, like I just said, from I sold it, the proceeds went directly to the title company. It should, you know, you can see that it went to the title company on our new home. It's on the new HUD statement. It's very easy to trace. But if you take that same $80,000, that net equity, and the person says, well, I'm going to put it in our joint checking account, and, you know, we're going to use some money for the down payment. We're going to use some money for new furniture and new drapes. And, oh, by the way, my spouse needs a new car. You know, sometimes people make these, and, you know, it's normal. We all do it. Sometimes people make these global decisions about how to use their money, and very accidentally. I mean, who, you know, nobody really, most people don't walk around saying, well, let's make sure that, you know, we're only using community money when we go buy a new car. But some of this can be avoided. So when those kind of decisions are made, in that situation where the $80,000 from the separate property real estate goes into a community account, and then the couple does a variety of things, what can happen is that $80,000 becomes what is called hopelessly commingled. And it means at the point of divorce, no one can like trace out that exact $80,000 to give back to the spouse whose money it was, because, you know, you can't really figure out if it went into the coffee table or into the car, or into the down payment on the house. You just really, and it's just, you know, basically water under the bridge, and it really can't be recouped. So record keeping, tracking things, that can go a long way if you get into a divorce situation. And also conversely, I mean, if you have a spouse, or you're entering into a marriage with a spouse that has a lot of separate property funds, it is good to be aware of these things as well. You know, if you're on the other side of that, if you're the spouse who you're buying a house with someone and they're about to put down $80,000 of their separate money, and later you might be at the point of divorce, just being aware that your spouse may be able to pull back that $80,000, I think, can go a long way. And if you have this knowledge, then you and your spouse can have these conversations as you go along. Okay, you're about to contribute $80,000 to this house. Are you going to expect to be reimbursed that later, or are you contributing that to our community estate? So it can, you know, can help have those conversations at a point in time that is a more comfortable point in time to have a conversation than when you're going through a divorce, because 99% of the time, if you're talking about that at the point of divorce, that person is absolutely going to want their $80,000 back. So that's just some stuff that you can do along the way that doesn't require a premarital agreement or a postmarital agreement. But let me tell you about those kinds of agreements. And let me also tell you, I've actually had people from this group call me about doing a premarital agreement, and I've said to them, you actually really don't need that, because you have, say, these 3 accounts, and what you really need is to keep good records, and just, you know, you don't need as much work as a prenup if you just keep these records. But some people really do need a prenup, and it can be helpful prior to marriage so that people really know the financial arrangement that they're getting into. And there are, you know, many people going into relationships where people do have quite a bit of separate property. and they want to alter the outcome in the event of a divorce. And the most complex agreements involve people saying, you know, we're both coming into this and we don't want any community estate to arise. We want everything that's mine to be mine, everything that is the other person's to be the other person's. I want my income to be my income. I don't want it to be community, and their income to be their income and not be community. So there are agreements that I've drafted that's the upshot. There's no community estate that forms. My view on those is those agreements are really only fair if you have two people that are pretty much on par with their financial life in terms of income and assets and so forth. There, you know, and short of that, there are a lot of people who come in with property and they say, I just want to identify that these, you know, 10 interests in real estate developments, for example, are my separate property. But I also want to change the outcome in the event of divorce to say that the income from these 10 real estate developments is not community. But anything that we do during the marriage, if I get involved in a new real estate development, that development will be community, and any income from it will be community as well. So sometimes people are memorializing, this is what's my separate, and they're altering what will happen with the income or certain assets. Or they're doing things like, yes, this is my separate property house. So I did one a while ago. The couple, actually, they were supposed to get married during COVID. They were not able to go through their marriage, through their wedding due to COVID. In the meantime, she became pregnant, and then they did replan their wedding. But during that period of time, when they thought they were going to be married, they were building a house. But, you know, he financed it, it was in his name, but it really was their home. She was working with him. They were doing all the, you know, designing and working with the architects and picking out all the finishes and everything. And so they did a premarital agreement to say, you know, that house is going to be our community property house. So it's altering the outcome that you might have in the event of a divorce otherwise. And I think they're most effective. You know, it's not a comfortable time to talk about those things, right? You're getting married. Of course, you don't think you're going to get divorced. They're not the most fun conversations to have. Sometimes you find out, for example, in that case, initially, he wanted to keep us, like, he had contributed a certain amount of money toward the build out. And she was surprised when we were in the process of doing the prenup that he wanted to preserve that money as his separate money, because she was thinking, no, this is our home together. It's equally going to be ours. Just even the emotional, psychological impact of that. But having that surprise before you get married, I think is far preferable to having it at a later point in time. So they were able to get past that, and, you know, I think it can help people walk into their marriage with more clarity about what you're doing together financially, which is already a really hard thing to do, right? Is to be sure with another person that you both are thinking the same thing about what your finances mean. It's that business side of the relationship that is often, I think, not very clear for people, both before they get married and in a marriage, and it can often lead to a divorce. So sometimes the idea behind a prenup or a post-nup, which I'll talk about in a minute, is let's have clarity about our financial partnership so we don't step into some of these potholes unexpectedly that could really cause us problems and damage our relationship. I saw a couple questions pop up, but since I'm talking so much, I wasn't able to read them.
Yeah. I've got one that came up that I thought was a good one that's probably pretty common to people in this group. So Dana asked, are accounts that are set up for children considered separate or community property? And I think in her example, it was a checking account, but let's say it's a checking account or a 529 account or an investment account in the name of minor children. What happens to that in the case of divorce?
Okay, so a checking, I mean, a simple account like a checking or savings account, that's community generally. And it can't really belong to the child because they're a minor. So when you set up an account for your child, it can have both, you know, the parent's name and the child's name, but it really belongs to the parents. So it's just community property. Most of the time in a divorce, let's say again, a checking or savings account, parents will do something with the account. For example, name one or the other parent the manager of that account, or they'll say when the money will be turned over to the children. Most of the time it's something pretty minor. Maybe it's an account where the child has been putting their Christmas money or birthday money or other type of money. But technically it's plain old community. I've never seen parents say, well, we want to divide that account between us. They'll usually come up with something. 529s are interesting because the type of account it is can only have one person named as the manager, and it's for the benefit of the children. So at the point of divorce, the money that's gone into the account during the marriage is community money. Just because there's one parent named as the manager doesn't mean it belongs to that parent. And somewhat the same thing, although 529 accounts, because they're for college or for educational expenses. Usually we will say, we'll have a whole separate part of a divorce decree that doesn't award the account to one spouse or the other, but we'll say this person will continue to manage the account. It will be used for these specific kinds of expenses, you know, tuition, books, room and board. Sometimes people put more specific things in there, like money from this account can only be used if the student is making A's and B's. And then often it will say that if the funds are not used for college or all of the funds are not expended for the child's education, then either the funds are divided between the ex-spouses or the funds will go to the child when the child is 23 or 24. But people do get in post-divorce fights about 529 accounts. So I would be, I like to be very specific about them.
Dana, did that answer your question, or do you want to jump on if you have anything more specific?
I think she asked about investing too. So there's the type of account and then there are the dollars that go into it. And if the dollars are from the community, they are still community funds.
Yeah.
It's just people may work out how they decide to use them for the children, child or children.
Got it. Thank you. Does anyone have any other questions on, and I don't know, Catherine, if you're going to keep going down this road, on prenups and postnups? Again, like, you know, Catherine mentioned, I know that she's answered lots of questions from people in this group about that topic because it, you know, it is a solution that's on the table and probably applicable to a lot of people. but not necessarily the only solution that is available out there. Does anyone else have any questions about prenuptial agreements or who they're for, who they're not for? I thought your explanation was great, by the way.
And I am going to talk about postnups too.
Oh, great. Yeah, you haven't talked about postnups yet. Okay. All right,
I'm
take it away.
thinking if there's anything else I want to say about prenups.
Yeah. Can you, Catherine, I have something I'd love for you to clarify for people.
Sure.
So one attorney can't represent two people who are signing a prenup, right? Each person, each party should have an attorney advocating for them if they are thinking about drafting and signing a prenup. Is that true?
Yes, and this will apply to prenups and postnups. So a lot of times, I think everyone's hope is that you do a prenup or postnup and you stick it in a drawer and you're never going to have to pull it out, right? But if you do have to pull it out, you want it to be enforceable, meaning you don't want the other spouse to be able to go to court and say, this can't be enforceable because of X, Y, and Z. And the two things that can make an agreement like that unenforceable or voidable is if it was unconscionable, which means it's just so wildly unfair. But it has to literally go against public policy, which is very rare. Or it was not signed voluntarily. And when you negotiate a prenup, I can't, as one lawyer, represent both people, because if it does come out of the drawer, it could appear to not be signed voluntarily if both people are getting advice from one lawyer. That's actually unethical for a lawyer to do, because at that point in time, the people's interests may be different. So to have it have the best chance of being enforceable, my dog starts barking, I'm going to mute and take care of her, okay? I meant to say that before I started talking in the beginning. I lost my train of thought. You want it to be an arm's length negotiation. So you want both people to have a lawyer. Usually it's one lawyer who's doing more of the consulting with one client, and the other person may just hire a lawyer for, say, an hour to review the document with them. But then you've got two lawyers. It's an arm's length transaction, so that if it ever becomes an issue, both people can say to the court, I had a lawyer, the other person had a lawyer. This was explained to them by somebody other than me or my lawyer. They had their own lawyer explain it to them. So if they now feel like it's unfair, that's on them. They have every opportunity to consult with someone. So that's a good point, Sarah. Because there's no point in doing these kind of agreements unless you want to make sure that they were done voluntarily, people understand what they say, people had legal consultation. So for example, if the agreement says, this business is so-and-so separate property, and any future income from this business is going to remain so-and-so separate property, that other person should have a lawyer explain that to them. And if they don't, you could have a problem when it comes time to enforce it. So it's not uncommon to have the spouse, the more moneyed spouse, actually pay for a lawyer to review the agreement with someone else. And they can be fairly lopsided, honestly. This is my personal opinion, but as far as what I can see, it is still women having children, and usually having more of the responsibility with children. I'm a mom. I love being a mom. you know, but when that falls more on that person, and this is a women's investing group, at that point in time, those agreements can seem even more unfair. I think I said this the last time that I gave this talk. I've done some prenups for some young professionals who coming in, you know, into the marriage where they're both professionals, they're both high wage earners, they both have some assets coming into the marriage. One may have more assets than the other, but they're not really considering, I mean, I think it's great that people go into marriages thinking, no, we are going to be absolutely equal partners. And I really, really hope it works out that way for a lot of people. But I still don't think that is necessarily the reality. And I don't know how that sounds to everybody. You're welcome to give me any feedback you want. But
you are probably the expert on this, as you know, as you've seen people come across your desk and you get to see how these negotiations and how marriages and divorces work out for people across the board. So I'm hopeful, and I'm pretty sure that the people in the group would say, like, yeah, most people go in with an idealistic view of what marriage looks like, but at the same time, it's, you know, you have to keep reality in the back of your mind for what the reality is in the aggregate for women across the board, or, you know, or divorces across the board and what they look like.
Well, and the people that have these really ideal, like perfect equal partnerships aren't going to come see me. So I am, of course, seeing the cross section of people that are getting divorced, and that happens for a lot of different reasons. But I think a lot of people go into marriage thinking, you know, if we have children, you know, we are really going to share this equally. Mm-hmm. And for a lot of different reasons, it just doesn't work out that way. Yeah. Or, you know, it's life. You know, you hit a lot of bumps in the road. I love the saying, like, life is what happens while you're making other plans, because you may have, for example, a child with special needs, or you just never know. And so I think someone like you can plan on that there are going to be things that aren't going to go the way that you thought. And often those things do impact your financial world. So a prenup, to some extent, in all areas of the law, we cannot come up with a solution for every single contingency about everything. But we can do some things to kind of set people up with different expectations so they're not surprised in the event that the relationship doesn't work out.
Yeah. And one more thing that I think we've talked about in the last two cases, again, this is starting to talk about, I think, some of the decision-making and emotions that come into something like this. You know, something we've touched on in the past is that what I've seen before in real life is someone is presented with a prenuptial agreement and says something to the effect of, I'm just going to sign this because I'm not in this marriage for the money, right? So in order to show that I am not a gold digger, for lack of a better term, or that I am not, putting money in front of my love for this person, I'm just going to sign what's put in front of me and maybe not hire an attorney or not push back or view it as a negotiation at that point, which, in my non-legal opinion is a huge mistake for people. But, it kind of comes back to this, the partnership idea that you brought up before, like that marriage is also a business partnership to a large extent. And it's certainly easy to forget that part, or maybe just not address it when you're in wedding planning mode, or, kind of in the first stages of getting the marriage underway, but that it's very important to be thinking ahead.
Yeah, and it's also natural to think, well, that person would never do this to me. If we're getting divorced in 15 years and we have 3 children, and I, you know, me, like, I'll bring up different scenarios. Well, that person would never treat me that way, or that person would never, it's natural at that point in time to think that way. And it's not that when I'm bringing up those scenarios, or when Sarah's saying what she's saying, that we're saying, oh yes, that, you know, literally personally, that person is going to treat you that way. It's just that you really, oh, let's see what she's going to, if she starts really going at it, I'm going to let her out. But it's that if you negotiate more for a worst case scenario, then you can always, by agreement, do something that's less than that. All right, I'm going to let her out. Sorry. Maybe you can
no problem.
some questions when I.
Yeah, perfect. So while Catherine takes a break to let her puppy out, which I love seeing people's kids and puppies and, you know, whoever, cats, you know, coming into the meetings whenever we have these. So while she's doing that, certainly, like, again, like, as questions come up as we're going through this, feel free to type up whatever questions you have, or if you want to message me or the group. I think that we're probably small enough at this point. We're a 25-person group, that if you just want to unmute yourself and ask a question, maybe just, I don't know, let Gwen or I know ahead of time, and then we can unmute you and have you come in and ask Catherine a question. It does sound like we are getting to post-nups here in a minute, so if you've been waiting for that, I think that's coming up next. But certainly, like, as you start taking all of this in, you know, certainly, like, family law, it's it's kind of creating this framework to think in, right, where you have the different estates that she talked about, the community estate, each separate estate, and now the prenups, the postnups, all of these things kind of work together. So I'm assuming that certainly, like, as we keep going through the material, something will pop up. So, all right, she's back.
Okay, postnups, and I don't mind going in between these topics, but a postnup is exactly like a prenup, except you do it after you're married. And you may wonder, why would anybody do that? And sometimes while people are in a marriage, financial issues come up and they realize, oh, maybe we need to do some planning. And if we do this planning and we put it in an agreement, it could save us from getting divorced. Or let's basically have a divorce or a partial divorce in our financial part of our relationship to save our marriage. I actually did one during COVID. I probably got more calls with inquiries about postnups than the last 5 years before the pandemic. Maybe it was just people being in close quarters, and maybe it was, you know, all the financial disruption that COVID caused. I can't really tell why, but people seemed more interested in postnups. Maybe they didn't want to go to the extreme of getting a divorce, but you know, like all of us, all the disruption that COVID caused, I think it just brought up a lot of issues for people, but they weren't necessarily one spouse did not out and out have what most of us would think of as an affair, but had sort of a online flirtation going on, and the other spouse learned of it. And I think that realization that a divorce could be on the horizon had that spouse start looking at what would be the financial repercussions for me if this meant a divorce. So the spouse that was having the flirtation did not want to get divorced. Really, neither one of them wanted to get divorced. But the spouse that learned of the affair started realizing, oh my gosh, if this goes that way, there could be really serious financial repercussions for me. So in that particular situation, what she negotiated was that in the event of a divorce, she would receive a very disproportionate division of the estate in her favor, as well as being awarded the house. So it can, it is a way to stay married, but build in consequences in the event of a divorce. Some people actually negotiate their post-marital agreement and the ink is hardly dry and then they're filing for divorce. It's almost like pre-negotiating your divorce. Does that make sense? And it's the same thing Sarah talked about. It needs to be arm's length, 2 attorneys, disclosure, so financial disclosure. And again, just back to kind of record keeping, wherever you are in your life, single, married, just knowing about the finances, knowing what there is, I think is empowering and important for women and for both partners, but we're talking about issues for women right now.
Could you?
Oh, sorry, go ahead.
I'm sorry. Could you do a post-nup about and say you won't take on somebody's debt? I could see that be a reason to do.
Yes. Credit card debt. I've seen people tax debt. Another reason that people might do a post-nup is they get a surprise. It's a very good point. Thank you, whoever brought that up. Thank you. Like they learn that their spouse has racked up a bunch of debt, or they thought their spouse was, filing the income tax returns and learned that they haven't filed tax returns for 5 years and they owe the IRS $100,000, or their spouse wants to quit a job and start a business. I did a post-nup that related to that. That was a little challenging too, because we had to plan both for what would happen if the business didn't do very well, but also what would happen if the business did do very well. So, kind of, shoring up, limiting liability, but also, kind of maximizing what if this thing really took off. But it was very scary to the one spouse wanted to encourage the other spouse's dreams, but it was scary to watch a W-2 income go away, in the middle of all that they were doing in their marriage.
One of the other things, Catherine, that you brought up that I'm hoping you can talk about a little bit is you mentioned the word like negotiations, right? Which we've brought up a couple times with negotiating a prenup or negotiating a premarital agreement, negotiating a postmarital agreement. Can you go back and talk a little bit about the difference between what happens when the people in the marriage negotiate and come to a settlement versus what happens when the parties in the marriage end up in front of the judge? Does that question make sense?
I think so. Are you asking it in the context of they've negotiated an agreement?
Yeah, my thinking is that, I think when some people who haven't seen this process a million times think about what happens in a divorce, right? They default to worst case scenario.
You're in court.
You're in court and the judge is deciding, and the judge has to follow those statutes that you talked about, right? I know the judge has discretion versus two people who have attorneys and are going through a divorce can negotiate and come up with different ways to divide property and come to financial agreements in order to facilitate a divorce. Does that make sense? And that those are
Yes.
two kind of different things.
Yes. So, yes. So a lot of time, divorce is scary and upsetting for people to think about already. And most people somebody just said like in mediation, and I'll talk about those different options. And a lot of people think, oh my gosh, I'm going to be in front of a judge. It's in public. This is humiliating. It's going to be so stressful, so expensive. And a lot of people do go to court, but really 9 out of 10 people, things are negotiated outside of court, like Sarah is saying, either between the 2 lawyers and the 2 parties, or as someone in the notes said, we gather information and go to a mediation to resolve the issues. And that is, again, 9 times out of 10, how most divorces actually happen. It's still not the most fun anybody's ever had in their life, but it's certainly a lot less scary than thinking about this hammer over your head that you're going to go to court. Now, we do a lot of times in a negotiation or a mediation or a collaborative process, which I'll also tell you about, we will use as a benchmark what we think a court might do. Any negotiation is only going to be as good as how much information, how much data you have. So I always tell people that one of the most important parts of a divorce process or negotiating a prenup or a postnup is let's get all the information that you need to make a thoughtful decision and that I need to give you good advice. So information gathering, again, record keeping is important. And then when we have enough information, we can go to a mediation. And for mediation, usually me and my client are in one room, the other lawyer and the client are in another room, and a mediator shuttles back and forth to facilitate a settlement. And we often do speculate about, all right, you've taken this position, do you think a judge would really do that or not? But a mediation, for example, you have far more control over the outcome and coming up with something that is a compromise between the 2 people, and it certainly costs a lot less than going to court. So mediation is usually 1 day, although that day can be about 8 to 10 or 11 hours. It's a long day of shuttling back and forth and trying to come up with solutions. It's usually effective. A collaborative process is another way that we facilitate agreements. And with a collaborative process, we use a multidisciplinary model. There's a neutral communication facilitator, and most of the time, depending, a neutral financial person. And the reason I say neutral, it means they're not on either person's side. They're working for the whole team. And then each party has a lawyer, and the lawyers are advocates, but the team works together to help facilitate a settlement. And a collaborative process it's very pragmatic, it's very future looking. So we take the set of problems that a family has to solve right now, and we look forward. We're informed by how people got there, but it's really not about, duking it out about, who did what to whom. You're here now, this is what you've decided. And the structure for it is that we use a series of meetings that are really no longer than 2 hours. So it is different than mediation. We use agendas, and they're working sessions of about 2 hours or less, and we tackle each issue at whatever meeting we are on. The neutral financial person serves as one person who's a clearinghouse to look at cash flow. So basically income and expenses, and then property division. So assembling that, what are the assets and what are the debts? And that's also a very effective way to get to an agreement that meets as many needs as we possibly can for people moving forward. I'm not sure I answered all the pieces of what you asked though, Sarah.
No, you did. That was great.
Well, and in collaborative, by the way, we all sign a contract up front, including the lawyers, that we're not going to go to court. And in fact, if we reach a total impasse and somebody has to go to court, the lawyers can't do it. They have to get new lawyers. So that preserves the integrity of the process. So, you know, really says like, really, we're not going to court in this case. We're going to do everything that we can to come up, you know, to problem solve, basically problem solve, and come up with solutions that work. And I do a lot of that as well as litigation.
Awesome, thank you. Yes, that was a little bit of what I was looking for. Yeah, thank you for touching on that. I know you have a couple.
Well, and I wanted another financial piece in marriage and divorce involves child support that I wanted to tell you all about. So child support is, it's determined using a percentage of the person who's going to be paying it, their net income. And in Texas, it's 20% of net income for one child, 25% for two, 30 for three, and so on, with a cap of someone having net earnings of $9,200 a month. I wrote it down, where is it? So that means if someone is netting, you know, $15,000 a month, we don't apply those percentages to the $15,000. We apply it to the first $9,200. And that's called guidelines support. So for one child, that 20% is $1,840 a month. For two, that would be $2,300 a month. And often I have people be really surprised about child support. So that's like the max cap, unless someone is going to agree to, you know, to pay more, which I don't find very common, honestly. So, and then someone's asking, the child support ends at the later of the child turning 18 or graduating from high school. So your typical scenario, let's say you have a senior in high school, they turn 18 in March, child support doesn't end until, you know, May or June when they graduate that year. If someone earns less, which obviously, you know, many people do, that percentage is applied to a lower number. People are often surprised that child support seems low. I am seeing more and more the courts being willing to do what are called offsets. So more people are doing equal time, what we call possession schedules. So that means equal time schedules with kids. And often, honestly, still 90% of the time I see that it's the man who's the higher wage earner. And I'll have those guys say, well, if I have my kids half time, do I have to pay child support? And the answer is yes, especially if there's a big disparity in earnings. So, and that there's starting to be a trend in the case law that child support really is for the best interests of the child. There are even some cases now where the higher wage earning partner who has the kids more is still paying child support to the lower wage earning person. Because the idea is that, you know, the child has, it's not so that the environments in the two households are identical for the child, but there's not, you know, poverty in one house and, you know, this fabulous lifestyle in another house. So it's to try to make it as good as possible for the child in both places. So yeah, but courts are also, if you have less of a disparity of income, let's say someone's earning $100,000 a year and the other person's earns $70,000 a year, and they're doing a half-time schedule, you might see an offset where you calculate child support based on both people's income, and then they net out, and the, you know, the person earning more pays the other person, but it's not the full guidelines child support. I'm seeing more courts trending that way. Let's see. someone asked, did they determine that the child support money is actually spent on the child? I get that question a lot, and people don't have to account for the child support being spent directly on the child, because it is for keeping a roof over their head, food, clothing, shelter. So if the person receiving it, you know, has an apartment and is paying rent and is providing food when that child is with them, then they're using their child support the way that they're supposed to. Someone asked about cryptocurrency also. That is becoming more of an issue, but it is same thing. It's inception of title, and yes, it's a community asset. I didn't see the exact question, but I just saw something about cryptocurrency.
All right, that's really helpful. Does anyone have any other child support type questions?
I did real quick. I don't know if you saw my question, but basically, so my situation is I just went through mediation, and so I'm waiting for the final divorce decree at this point.
Okay.
And I have twin sons that are going to be seniors this year. So that's why I asked when, so that I know. Yeah, so that's why my question surrounded that. But one, I wanted to know, will the last one be in May or June? Because the graduation ceremony will be likely in June, pending no other surprises around the pandemic.
Yeah.
But yeah, I didn't know. I know from my understanding is there's no legal obligation. There's no legal obligation for him to support the two sons. But I didn't know if I had any recourse, and I'm wondering if I would need to go back to my lawyer to have them amend. I don't really know.
Do you mean, Karina, do you mean to support them after they graduate from high school?
Right. So we have a third kid who's in college right now, and he's been giving her money, but I don't know. His relationship with the two boys it's not very good because they've pretty much written him out of the life. That's another call, but in any case.
I understand that part too, yeah.
Right, that's a whole nother call. But so they really don't have any communication, and I don't want him to feel, I'm trying to fight for my boys. That's really what I'm trying to get at, and make sure that they're taken care of, that he's contributing to them as they become older and try to get their place in this world.
That's hard, because that child support obligation does end when they're no longer a child. So when they're no longer a minor, although it does go through high school. So there isn't any obligation beyond that. One thing I have been seeing more of, since people can now keep their children on their health insurance until they're 26,
right,
is I've seen people reaching agreements that the person who maintains the health insurance will keep the child on their health insurance as long as they can, you know, until the child has their own health insurance, for example. But yeah, a lot of people ask, you know, is there something we can do about, you know, paying for college or paying for weddings, paying even for cars, which, I mean, cars usually happen when a kid is still a minor.
right,
but those expenses when they're not a minor, some people may want to make a contract about that, but most of the time they don't. And that's left, just like people that stay married. So for example, my parents, they're still married. I'm the oldest of 5 kids. When me and my siblings were college age, my parents disagreed about how to, you know, fund college. And so they just had to figure it out. And then they, you know, decided what they decided. So that's usually left in the realm of, you know, what adults decide about contributing or not contributing to their adult children.
I see. Okay.
As it would be with married people. I mean, I think I understand why it's natural that people that are divorcing would like to reach agreements, you know, that go beyond kids being 18, because, I mean, especially right now, and especially with COVID, you know, our kids are, you know, I think we're all facing probably longer times that they're dependent on us. It's, you know, it's not necessarily the days where you're 18, see you later, you know, get out of the house. But yeah, the law does not provide for that.
Gotcha. Yeah, I was just trying to see if there's any other recourse I could take. You know, I mean, like you said, it's just being 18 these days, it's different. You're not really quite independent. So I was just trying to figure out a way for them.
I think the health insurance is very helpful because things are so up in the air. And I think what I've seen, most parents, if they're able to continue to provide health insurance for their children up to that age, are willing to do that.
Yeah, I've always carried the health insurance, actually.
Oh,
so
okay.
That's the kids are good. I'm not worried about them. It's just the other part that's like, well, you know, we'll swing it.
Yeah.
All right. Thank you so much.
You're welcome. Just looking through my notes to see any other topics that I haven't covered. Let me just say a little about the divorce process overall. Whether you go to court or end up in mediation or do a collaborative process, I would say there are 5 kind of big phases to a divorce. And the last phase, which it sounds like, Karina, you're in, is the drafting phase. So decisions have already been made, but the lawyers and paralegals need to draft what will make it effective with the court. And that can be kind of a frustrating phase for the people going through it, because you just want to be done, and it still can take, this still shocks me, but it still can take 2 or more months to really complete all the paperwork and get it through the court. Right now, the courts are still doing things by electronic submission. And in Travis County, we have 3 new district judges. And there's 1 district judge that I had a final order stuck with that judge. It took her 4 months before she signed it. So it's very frustrating for people. The first phase is also not a really fun phase, but it's that limbo phase, trying to decide, should I divorce? Who should file? If we do that, where will people live? What will we do with our kids? How will we pay our bills? So I would call that the temporary order phase, and temporary refers to the temporary time in your life that you're going through a divorce. And then the second phase is just pure information gathering. I know I've said it a bunch on this talk that I really feel like that phase with a divorce and a lot of other things in life is really critical, to have all your information really assembled and be very clear so that you know what you're dealing with. The third phase, once people have the information to make decisions, is generating options, so looking at spreadsheets and looking at what are options for you and your spouse and your child that might work. And then the fourth phase is it gets resolved, either in a mediation or between you and your spouse, or in a collaborative meeting or in court. It's resolved. And then the fifth phase is the documentation phase. I will also say I've seen more, in this talk, I typically haven't talked about this, but I think it's relevant. I've seen more modification cases during COVID than I usually see. And a modification case is after your divorce, so you're totally done, that event is over, and you know what you're living with. There can be a modification case, and that involves issues related to your children. And modification cases are really hard. I've seen a lot of people attempting to modify their child support. And again, primarily what I've been seeing is it's primarily the person paying child support trying to lower their child support. And that is still more typically the male, who has had some kind of decrease in their income. But, you know, conversely, all of us were affected by COVID in some way financially. And those modification cases, so in a divorce, you still have your community estate, and your attorney's fees are an obligation of the community. So that means if your spouse goes out and hires someone, and that someone requires a $15,000 retainer, you have equal access to the resources of the community to also have a $15,000 retainer to hire a lawyer, which that's also, I want you guys to know that. Sometimes I hear from women, well, it's his money and he has the money to pay for a lawyer and I don't. But in a divorce, those funds come from the community, and both partners should have equal access to the community resources to do that. In a modification, that is not the case. So you can't get attorney's fees from the community estate because there isn't a community estate. So I had some real situations I thought were very unfair last year. So if you are divorced, you might, same thing, be, you know, just careful about if there's a modification on the horizon. So I had a case, for example, where the ex-husband filed a modification to lower his child support. The parties had 3 young children who were really close in age. The children were primarily with the mother. He did have a reduction in his income, but his income went from literally about $700,000 a year to about $250,000 a year, which, yes, that is a huge reduction in income, but earning $250,000 he's still a high wage earner. She earned netted about $1,800 a month. So he lost that hearing, but she had to come up with her own attorney's fees to defend against it. So a modification case can also be a financial event that is hard to deal with because there's no community estate to draw funds from. And even if you're defending against something that seems ridiculous, like that situation, you're on the spot for it. And I had about 4 of those last year where the ex-husband was suing to reduce his child support, and the ex-wife was having to somehow, the choices were you either capitulate or you find a way to pay an attorney to defend you. Any questions? I'm open to talk about any of this.
So we did have a question that came up from Karina, but before I read that one out, there was a question from Sunita that we missed from earlier that involved remarriage and then death and inheritance. So Sunita's question is, what happens if I remarry and have children from my first marriage and I die? What happens to my estate and my children's part of the inheritance?
You cut out for a moment there. Can you say that last part? What happens?
What happens? So in this situation, what happens to my estate and my children's part of their inheritance?
Well, especially if you have children and you remarry, you're going to want to do a will. And that's in the estate planning arena, which actually is not in my specialty, so I can't talk about it, but I do have a lot of good people that I can refer people to. So if anybody needs a referral to an estate planning lawyer, just give me a call or email me and I'll give you some names. But with a will, kind of like a prenup or a postnup or any of these other agreements, your children in the event of your death would be protected by your will. And if you don't have a will, again, this is not my area of expertise. A will does the same thing as kind of a postnup or a prenup, which it alters the way things happen if you don't have a will. So it's something that you would go and say, hey, how can I, in the event something happens to me, make sure that my children receive whatever it is of yours that you want them to receive. I'm curious about that cryptocurrency question. It's coming up a lot. The issue of cryptocurrency, Bitcoin. There's that other thing that I'm forgetting the name of. It has chain in it. Chain. Are you seeing a lot of that, Sarah, in the work that you're doing?
Yeah, everyone's talking about cryptocurrency. Are you talking about blockchain?
Blockchain.
Like, yeah. Dana, if you're still on the call, do you want to jump on and be more and let us know what your question was specifically about cryptocurrencies, like as property? Like, I think your question is whether they would be considered community or separate property. But do you have any additional detail you'd like to share with us?
Yeah, hi.
Hi.
I guess my question had to do with like my husband. He does a lot of cryptocurrency investments, and I know that right now it's not a regulated field. So anything that he made off of that, in the event that we did end up divorcing, I mean, is that considered community property? And I guess if it is, how does that work, considering it's not a regulated field? I guess I don't even think that they pay taxes on it. I think, well, if they cash it out,
you're supposed to be paying taxes on it, by the way. But continue. Sorry, I didn't mean to interrupt. Keep going, because I think I know what route you're going down.
Yeah, I just want to know, like, let's say in the event that he makes, I don't know, let's say 50,000, and he hasn't, cashed it out to where he's, using it as just, he hasn't liquidated, he's using it just for spending money or whatnot. He's just constantly reinvesting it in other cryptocurrency. How will that work in the event of a divorce? Would I get like automatic half of that, or is it just something that Texas law doesn't take into account?
Okay, so
do you start, Catherine?
I was actually at another attorney's office probably 2 months ago or so, and they're a financial advisor person was there too, and we were talking about this topic. And for many, many lawyers and judges, where we are in the conversation is going like, what is it? Can you explain to us, what is this thing? And we're just like getting our minds wrapped around, what is it? How do you use it? Like what's the other one? It's not blockchain, but it's NFTs.
Oh, yeah. Yeah. Non-fungible tokens. Yeah.
And we're like more of that too, like we're trying to get like a grasp of what is this even? We have a better grasp of cryptocurrency. But it's same thing, inception of title. If it was acquired during the marriage, it is community property. It can and will be divided in a divorce. And I think the question more right now legally is, how do you divide it? What are you dividing? How do you do that? So I'll give you another example, like restricted stock units. So a restricted stock unit, somebody that works at AMD, for example, AMD may award them, 900 restricted stock units, and they have a three-year vesting schedule, let's say, and people are getting divorced somewhere in that vesting schedule. So we had to figure out, as companies were creating these kind of job entitlements like stock options and restricted stock units and other incentives, how to, in a divorce, divide them. So with the restricted stock units, we did figure that out, and we came up with a proportional formula basically to divide them, and then figured out mechanisms for the spouse whose names the restricted stock units are in to exercise them and then provide the money to the other spouse, because we couldn't actually, unlike dollars, for example, we couldn't actually give the other spouse the restricted stock units. And so some of these NFTs and blockchain and maybe cryptocurrency, I think we're in the process of figuring out how to divide. We know that they're community, and we know that they need to be divided, and we know that we will divide them. It's just how to divide them. And often it's becomes incumbent on the lawyers to figure that out. And then we have to educate the judges on these things that are fairly new. A lot of times the judicial system is not really at the cutting edge of figuring things out like this. But we do know that they can be figured out, and I'm starting to see a lot of emails on this topic, and many lawyers and judges we're kind of at the bottom rung of just even we understand the concept, conceptually we understand it, but we don't know. It's this is the cup, what is a blockchain? What is an NFT? So we need to understand it first before we can figure out how to divide it. But yes, it can be divided, and it will be divided. We just are not sure the mechanisms yet.
Yeah, and just to piggyback on that, this is Sarah.
Well, let me just say one other
IRS
thing. I also in the understanding of it, it also seems like something that is somewhat easy to hide. So we're also trying to figure out the ways to find NFTs, cryptocurrencies, blockchain, and so forth. Because it seems easy to hide. And certainly if we don't know what they are, it's going to be more easily hidden. So we're also looking at that. Sorry, Sarah, go ahead.
No, that was perfect. I was just going to say on a basic level, the IRS considers cryptocurrency to be property, just like any other type of property, which means, you buy Bitcoin, you buy one Bitcoin for $30,000. If you sell it for $40,000, you're supposed to pay capital gains tax on the difference between what you bought it for and what you sold it for. And that's not a gray area anymore. There's IRS publications on that. And so if you're not paying taxes on buying and selling cryptocurrency, you need to, right? I think the IRS will be coming for you, right? They're starting to, I don't know if you noticed on your 1040 this year, there's a box at the top of the form that says, have you owned cryptocurrency? Have you owned it? Have you traded it? Have you sold it? Check this box if you have. And so I think you can know by the prominence of that this is becoming more regulated, Dana. I think it's interesting what Catherine said about how does a court divide it? I'm thinking about a 401k that you can send something called a qualified domestic relations order, right? You send a quadro to the company divides a 401k into two parts. You know what a quadro is and you know where to mail it, right? And you know what needs to go in the quadro to make that happen. But in this case, if you have a spouse who owns 10 Bitcoin, who do you send a quadro to or where does the direction go on the blockchain to change ownership from one spouse to another spouse? I mean, I'm sure that there's all sorts of fun stuff coming up around that. But certainly, if you know that cryptocurrency or other digital assets or NFTs exist, and you can put a dollar amount on what they're worth, then that's included in the community estate. It's included for division, right? So if you know that it's there, because it's just, even though it's a weird brand new type of property that everybody's getting used to now, it is considered property as far as almost everyone who's, I don't know, has a say in this type of thing now agrees that it's property. That's a really good question, Dana. What else, everybody? Catherine, did you get through your agenda? That was amazing.
Well, this is just random too, but what I just thought of too is Texas doesn't have a legal separation. So sometimes people just work out their own separations, but know that even if you're separated, if you're not divorced, there's a community estate.
So if you're not divorced, you're still married.
You're still married.
And there's still a community estate.
Right. So, and this is not uncommon either. I mean, this is kind of an extreme. I consulted with someone where for religious reasons, they did not want to get divorced, but they'd been separated for well over 10 years. And they sold their marital residence and they divided the money. So let's say they each had originally $300,000. They've been separated 10 years. There's this other odd reason why they may actually have to get divorced, and it involves one of the partners developing dementia and something that was happening with someone actually accessing their money. But in reality, even though they each had two piles of $300,000, that $600,000 is still all community.
Mm-hmm.
So I don't know if they're going to divorce, but with the person now having dementia, it could be that all that money should be with the other person because the person with dementia is not going to be using it. So even if you stay married, you're separated, you sell your house or do something like that, and you divide the things between you, all it means is you've put the community property into two separate piles. And I've seen it happen from time to time where one person saves theirs, they save their $300,000, the other person spends through it, and then it's time for divorce, and guess what? That $300,000 that the person saved is still there to be divided as community property. It doesn't matter really at all that the other person spent, because it's all, people thought they put it into two different buckets, but it's really in the same bucket.
Yeah.
That's the only other thing I could think of.
Yeah. There's one other thing that is related to divorce that came up in one of Karina's follow-up questions, and it's about Social Security benefits. So her question was claiming a Social Security benefit based on your ex's, your former spouse's earnings record. So basically, like, can you draw Social Security on your spouse's earnings record after you were divorced?
Yeah, that's really important. So a Social Security benefit is not property. It's a government entitlement. It's a federal government entitlement. But if you've been married for over 10 years, and when you're eligible to draw Social Security, they can calculate your benefit based either on your Social Security benefit or your former spouse's Social Security benefit. And I believe it's 1/2 of their benefit if you were married for 10 years or more, even if it's an ex-spouse. And if that benefit is more, that's what you will want to receive. We are seeing more and more, I don't like this term at all, especially since what I did with my hair during COVID, but they're calling it gray divorce. And we need a new, I don't know. It's like super mature, awesome people divorces, where these kind of issues are, people are living longer and realizing, I don't know if I can do 20 or 30 more years with this person. And some of those issues are coming up about Social Security. and the like.
Yeah. That's definitely something Social Security in general, like you have a benefit at your full retirement age, and then the benefit is reduced every year that you take it early. And usually like your own benefit grows for every year you postpone. Most people's full retirement age is somewhere between 66 and 67. With a spousal benefit, you'll want to call the Social Security office and find out what the benefit amount will be at your different ages to find out which one that you take. But just know that in general, Social Security, you can start taking it usually at age 62, between age 62 and age 70, and the amount that you get is less if you take it early and more if you take it later. But the Social Security office should be able to run through those numbers with you. Just give them your spouse's Social Security number, and your spouse doesn't know. Your spouse doesn't need to go give permission. Your spouse is not, your ex-spouse, I'm sorry, your former spouse is not part of this discussion at all anymore. If you were married 10 years, they will run those numbers for you.
And their website has actually become really good, as is the IRS website. I mean, but I would say especially the social, they're, and you can, make an account and see where your account is. It's really worth doing, I think. It's not as much red tape as it used to be online.
Catherine, there's one more question that came in the last 30 seconds, speed round. Any other documentation that you need while married? So this is from Eleanor. So we talked about a will. She mentioned like a healthcare proxy, maybe something like a living trust, but what other documentation is good or important to have while you're married?
Honestly, that question is better asked of an estate planning lawyer.
Yeah.
In that realm. And again, I'm happy there are really good people in town. I can give you some names. Karina asked about this on the Social Security. It's actually, they look at your benefit or 1/2 of your ex-spouse's benefit, and whichever's higher. So it's not the other person's full benefit, Karina. Okay.
Oh yeah, sorry, I may have misspoke on that too. But yeah, a spousal benefit is 1/2 of your spouse's or former spouse's benefit. Cool. Catherine, this has been amazing as always. I like how we talked about some of the greatest hits that you've touched on all 3 years, and some new stuff came up for the first time. So as always, like, I don't know, I feel like this is probably like up there with one of the most important meetings we have every year, and we try to do it every year for that reason. And I just can't thank you enough for all of the time that you put in to help us wrap our minds around this.
I'm really happy to do it, and I'm happy for people to have the information before you're in the situation.
Yeah, absolutely. So everyone on the call, tell your friends' friends. If there's a question, reach out to an attorney and pay an attorney to answer your questions. Don't try to make these decisions based on what you think your friends think. That's something that I always come away with from this meeting, is like, don't rely on what you think you know in this type of situation, because the laws are different in Texas than they are in a lot of other places. And unfortunately, like Catherine said, most of the knowledge you get is when you're actually going through it, and that's a little late. So,
and then everybody will have advice for you, and a lot of it is you're already in a really anxiety-producing situation, and everybody's situation is unique, and there's a lot of things that are in common, and everybody will have advice for you. So it can can increase anxiety to hear, oh, well, my neighbor's, this lawyer got this thing for my neighbor, but you don't even, it really depends on your situation. So I'm always happy to field calls or consult with people, if I can help.
Yeah, and we'll send out Catherine's contact info in the follow-up email too, and when we post this to the YouTube channel. So in the meantime, keep your eyes peeled for the July meeting, which I believe Lori's going to talk about how to pay for college. So we're just going to keep going with like family-centric topics here, which is awesome. So Lori Watts is on July 24th at 2:30 is going to talk about how to pay for college. We will send out an invitation to that meeting. We'll send out a follow-up to this meeting along with the link to the video channel so you can watch it again. Again, like reach out to myself or Lori or Gwen if you have any questions about the Austin Women's Investing Group. And if you have any questions for Catherine, you can reach out to her as well. All right.
Thank you, everybody.
Weekend, everybody.
Yeah, have a
Thanks
good
for
Saturday.
coming.
All right.